Sign your name right there. You want to sign this?
Before this case even gets moving, something critical happens that most viewers might overlook if they blink. A constitutional right is waived. A jury trial is not a formality. It is one of the strongest protections a defendant has. 12 citizens instead of one judge. Different standards of persuasion, different psychology. When someone waives that right, it immediately signals strategy. Either the defense believes the facts play better to a judge, or they believe a jury would be unpredictable or unforgiving. Judge Simpson does exactly what he's required to do here. He slows everything down, confirms understanding, and locks this waiver into the record so it cannot be challenged later. This is procedural, yes, but it's also decisive. From this moment forward, everything rests in the hands of one man, and that raises a serious question for you watching. If your freedom were on the line, would you trust a single judge, or would you want 12 strangers deciding your fate?
She doesn't. Mr. Fridge, you're waiving your right to a trial by jury.
Yeah.
And you understand you have an absolute and constitutional right to have the matter tried before a jury.
Yes.
All right. Based upon the statement of counsel, the defendant court will consent to have the matter tried before it without a jury. Non-jury trial in this matter will be set for March 24, 2025, 9 a.m.
Judge, thank you very much for that. I would also ask if the court would consider an oral bond motion, Judge.
Briefly.
Very briefly, Judge. Judge, my client's a good kid here. He acknowledges that he missed a court date. His car broke down. He's not a flight risk. He wants to deal with these issues. He apologizes to the court for not being here, but there's a $25,000 bond.
He lives in Ipsy.
I understand his car still broke down, Judge. All I can say is, what I'm
On
asking.
Gulf side.
Pardon me? Why, that's near my house. I could have picked him up maybe, but that being said, Judge.
He could have walked.
Judge,
Go ahead.
if we can get past that, please. You being the considerate judge you are, Judge, I mean, in all seriousness, I'm asking if the court would reduce that $25,000 bond to a PR bond, Your Honor. I can better represent him if he's out of jail. He does have some minor bonds in other
It's already
places.
been reduced.
Pardon me?
I think.
I was under the impression it was $25,000.
I have 10,000 cash surety. And that was, he came in and was arraigned by Judge Barr.
Okay, well, I wasn't aware of that. Judge, would you consider a 10% of that?
Response from the people?
Your Honor, I would just have concerns. According to my notes, there were 3 failure to appears on this file
Yes.
for different varying reasons, like didn't give the date, didn't know, things like that. So I would just have concerns that he would attend future court dates given his history of.
This single statement does more damage to the bond request than anything else said so far. 3 failures to appear is not bad luck. It's a pattern, and courts run on patterns. Judges are trained to look past explanations and focus on outcomes. Didn't know the date, didn't get notice, didn't understand. These explanations might work once, maybe even twice, but by the 3rd time, they stop sounding like misunderstandings and start sounding like avoidance. From the court's perspective, this isn't about sympathy, it's about predictability. If the judge can't trust that you'll show up voluntarily, the court has to use force instead. And once that threshold is crossed, bond becomes leverage, not courtesy.
If I can just briefly respond, Judge, he wants to resolve this. We have a bench trial now for March 24th. I'm asking again, he apologizes for not being here. He won't let it happen again. Would you at least give him a $10,000 10%?
Here's the problem, is that after his arraignment in October 21st, 2024, he got a court date. He didn't appear on that court date, had to issue a warrant. He then somehow or another got in, may have been a warrant recall. I then adjourned, once he came in, the proceeding from whatever date to December 15th, 2024. Adjourned to January 6th, 2025. January 6th, 2025 comes around, he bench warrants again. He then comes in, magistrate looks like gives him, Magistrate Ortella gives him a PR, sets the pretrial for February 10th, 2025 at 12. February 10th comes around, guess what? Doesn't appear.
That's the day he had the car problem, Judge.
Okay. But he didn't, how'd he come back into custody?
Oh, I got stopped. I was
You
in.
got stopped, meaning, and all that means to me is he didn't come here, he didn't come down and try to take care of anything. He got stopped, they saw him, he gets arrested on the warrant.
This is the turning point. Judge Simpson doesn't argue. He reconstructs. And reconstruction is deadly in court. Once a judge lays out a timeline like this, the emotional argument is over. What stands out most is not the missed dates. It's how the defendant returned to custody. Not by voluntarily appearing, not by calling the court, but by getting stopped. That tells the court everything it needs to know. Accountability wasn't chosen. It was forced. Judges extend grace when defendants demonstrate responsibility, but responsibility can't be accidental. And at this moment, any chance of a bond reduction effectively disappears.
Then he comes in and for whatever reason, Judge Barr reduced his bond to a $10,000 cash surety as opposed to $25,000. And that's where it sits right now. And so I have no reason to believe that he's going to appear.
Just
For bond reductions.
Just for the record, he does contact me and I tried to do the warrant recalls. But, okay, thank you, Judge.
Bond will continue. Thank you.
Thank you.
You're welcome. And the next person, or
They're
I mean, I could do some nods in between. It's fine with me. Yes, sir.
Okay, thanks.
They might be better.
Court calls the case, People versus Eric Bragg.
And on behalf of people,
Good afternoon, Your Honor. Calvin Hawthorne appearing on behalf of Eric Bragg, who appears via Zoom. Mr. Bragg, please unmute and state your name.
Good afternoon, Your Honor. My name is Eric Bragg.
Date and time set for sentencing. Have you reviewed the pre-sentence report?
Yes, Your Honor, we did have an opportunity to review and discuss the report. We have no material additions, corrections, or deletions, and would ask the court to follow the recommendations.
All right. So Bragg, is there anything you'd like to tell the court before I impose sentence?
Good afternoon, Your Honor. I am grateful for this opportunity to go before the court, and I would like to apologize to the court for my actions involving my ex and that they will never happen again. I wish to better my life, not only for my new fiance, but for my newborn baby daughter to see how a man should treat a woman and respectfully and peacefully.
and Your Honor, I did want to, was the court in receipt of the written impact statement from the victim?
I did not see one. Unless it was attached. Was it handwritten?
Typed, Your Honor. I provided it to probation, but I understand Teresa's out.
Okay. If you could send that, I don't have a copy and I don't know where Elon is. If you could send a copy to Ms. Hartwick, let me pass this matter briefly because I'd like to review that before I send. That's all right. Thanks.
Thank you.
Court does call the case People versus Anthony Ned.
And on behalf of the people, Your Honors.
Your Honor, attorney, we have Mr. Anthony Ned. Mr. Ned standing on my right. State your name.
Anthony Ned. Thank you. All right, what are we doing?
Again, good to see you, Your Honor. On this matter, I submitted a mitigation letter. I was informed that it was forwarded to your office recently. And
I didn't have to check it. I just got it. So
it was just got this. Okay. So I would imagine at this time there's maybe some more needed time for information to present an offer.
Absolutely, for the people, Your Honor, this docket is being transitioned to the setup, so people.
Why? No, see, Nobody,
I was
nobody,
gonna tell you-
nobody asked me. No, I heard through the grapevine. Nobody had the respect to come to me and to tell me that. Because
I'm so sorry.
I don't like change and I don't like strangers.
But you do like to send them.
Well, I asked for a dismissal.
I like strangers even more than you. Anyway.
I was able to give you that mitigation report late last week. I did forward it to Ms. Sunda, but if you could have just 1 week to review that because the defendant's, or I guess you don't have a docket next week, do you, Your Honor?
I have no idea. It's all changing. I don't know. This is what I'm talking about.
This moment isn't about legal arguments. It's about emotional volatility. Anthony Ned isn't disputing facts. He's reacting to confusion and lack of communication. And while frustration is understandable, courtrooms are not built to accommodate emotional outbursts. Judge Simpson allows him to speak, but notice what doesn't happen. The court does not slow down to soothe him. Procedure stays intact. That's intentional. Judges are responsible for order, not comfort. What's happening beneath the surface is more important. This defendant feels out of control, and that perception alone can work against him. Courts expect defendants to rely on counsel, not personal expectations. When a defendant feels blindsided, it often signals a breakdown between attorney and client, but the court will not fix that for them. And here's the critical point. Emotional instability, even verbal, can reinforce the court's decision to maintain strict bond conditions.
Probably, I don't have a docket next week, do I? That Zenda did that, didn't she? Yeah. Okay, when's my next docket? March 17th, 2025, 1 p.m. Is anything else holding Mr. Ned?
And that was my next question. I was informed that he has a bond denial, but I'm not exactly sure why. So I asked also for a personal conscience bond because I know he has matters at home to take care of rent, his car note, work.
Well, but the bond denied on this case
I
or
believe
on
so.
another case?
I believe it's on this. This is the only case he has.
I'm double checking. I think he has a parole.
Oh,
I thought, but maybe it's a different person.
Your Honor, I had a bond violation.
in this case? That was because of violation, must have been.
Your Honor, I had a bond violation report from January 29th.
That's why. That's why.
This single clarification explains everything. A violation report is one of the fastest ways to shut down any bond modification request. Once a violation is on record, the presumption shifts. The defendant is no longer viewed as someone who might comply. There's someone who already didn't. At that point, bond is no longer a trust mechanism. It becomes containment. Judge Simpson doesn't debate it. He doesn't lecture. He simply confirms the existence of the violation and moves on. That brevity is powerful. It tells everyone in the room that this issue is settled. No amount of argument can erase documented non-compliance. And for viewers, this highlights a hard truth. In court, paperwork beats personality every time.
All right, so his bond will continue where it is. I'm not going to change it
Okay.
at this point. All right,
So 17th.
17th, 1 p.m. Thank you.
Thank you, Your Honor.
And Mr. Hawthorne, have you seen this?
Yes, I have. And I also forwarded a copy to Mr. Bragg as well.
All right.
Want to prosecute. She keeps texting him. They were out to dinner the night before.
Court recalls the case of People versus Bragg.
And then on behalf of the people,
Calvin Hawthorne on behalf of Mr. Bragg.
Eric Bragg here, Your Honor.
All right. Go ahead. I've now reviewed it, yes.
We would ask the court to follow the recommendations.
And even in light of that letter, and I've received some communication regarding this case from Ms. Polera. It's a sentence of the court. I'll place you on 12 months probation. You're to pay $555 fines and costs, $360 probation oversight fees. When can that be paid?
He will have that paid today, Your Honor.
That's to be paid today.
Yes, I can.
There's
pay
to be
that.
no use of alcohol. No use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. There's to be no contact with Celine Benham. No going to the residence or employment of that individual. No assaultive, threatening, or intimidating behavior. No possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll schedule a review hearing May 5th, 2025 at 1 p.m. I'll order 180 days in jail that is suspended. Thank you.
Thank you, Your Honor.
Court calls case People versus Daquan Hardrick.
And then on behalf of the people,
Hey, you would need to do the waiver part.
Yes, Your Honor. Assistant Public Defender Natalie Pay, on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to therefore rise, one would therefore waive.
All right. And the court for its part does not believe that a conflict exists either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. All right.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with it on behalf of Mr. Hardrick, who stands to my right. Please state your name for the record, sir.
Daquan Hardrick.
All right.
Thank you, Your Honor. I have discussed this matter with my client, and at this time, we wish to set the case for final settlement conference.
Jury final settlement conference will be set for
April 11th.
April 11th, 2025, 9 a.m. Jury selection, if necessary, will be April 14th. April 14th, 2025, 8:30. Both of those proceedings are in person. Yes.
it's my understanding that the victim in this case is here and would like to ask the court for a contact the defendant.
All right. And do the people have a position?
Your Honor, I'll leave it at the discretion of the court.
All right. He needs to step back. Hello. What's your name?
Lindsay Hardrick.
All right. What do you want to tell me?
Is right if I read it,
Pardon?
read a letter, read
Go
my,
ahead.
we all make mistakes. It's what we do next that counts. I'm asking the court to remove the no contact order between my husband and I, as I'm not able to process the necessary steps alone to move forward, whether it be divorce or if we're able to come to a resolve through therapy and other resources. And also there's an important health matter that I need to discuss with the client that I feel should come from me and no one else. Our marriage is not toxic. There's just a lot of unresolved trauma that both of us are dealing with that we weren't aware of until we came to certain situations that trigger the trauma that had been lying dormant. And now that I've been able to come into realization, processing everything that has transpired, I have a better understanding of what needs to be done. I just don't know if I'm to move forward with certain decisions if I'm not able to communicate with my husband, as I don't know where his decisions lie. The last 22 days have been the hardest days of my life. And not being able to have or talk to the person I need the most has made it even more difficult. I understand the severity of the situation that happened, and I hold Daquan and myself accountable for the actions that were taken. However, I do not hold them against my husband in the matter that he cannot change. I know he has the willpower. He just has to give the will to achieve the power. Allowing us to have contact will not cause harm or threaten my safety. As long as my husband is willing to communicate, I am.
This is one of the most emotionally complex statements a judge can hear. A spouse asking for contact, acknowledging harm but expressing hope, puts the court in an impossible position. Judge Simpson must weigh her autonomy against systemic risk. Domestic violence law exists precisely because victims may minimize danger in moments of emotional pain. The court isn't questioning her sincerity, it's questioning safety. And safety always wins. What makes this moment powerful is the judge's restraint. He listens fully, without interruption. But listening does not equal agreement. The law demands prevention, not reaction. This is the system saying, we believe you, but we must protect you anyway.
That's all.
All right. Ms. Pate, where would, I don't want to put the address out there, but if I were to allow contact, but not allow this individual to reside at that address?
So, Your Honor, to be candid, I believe the contact that would be able to be possible to happen at this time would take place via the phone. So Mr. Hardrick has a MDOC hold with his bond denied. I did speak to his parole officer directly this morning. In short, the hold will be staying until this case is resolved one way or the other. So I would leave it at the court's discretion, but I do believe my client would like to be able to have phone contact with the complaining witness while the case is.
What I will do is I will delete the no contact provision. I will allow no non-consensual contact. Young man, what that means is that if she doesn't want to talk to you, then, you can't just keep calling her.
This is judicial precision at work. Judge Simpson doesn't remove protection, he refines it. By allowing consensual contact only, the court returns agency to the victim while keeping firm boundaries in place. This is not leniency, it's controlled access. The warning is explicit and public. Any pressure, any harassment, and the privilege disappears instantly. Judges rarely explain conditions this clearly unless they expect scrutiny later. This also places responsibility squarely on the defendant. Consent must be ongoing, not assumed. This moment reflects the court's attempt to balance compassion with accountability, something far harder than simply saying yes or no.
If she makes it clear to you she doesn't want to have contact, that's it. Understood? All right. Thank you, ma'am. His bond will continue otherwise.
Thank you very much.
Thank you. Court does call the case People versus Jeremiah Driscoll.
And on behalf of the people.
Public Defender Natalie Tate with it on behalf of Mr. Driscoll, who should be present via Zoom. Sir, can you please unmute and state your name for the court?
Yes, Jeremiah David Driscoll.
Fine.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity to review the PSIR and have no changes or corrections and would respectfully request that the court adopt probation's recommendation.
Sir, is there anything you'd like to say to the court before I impose sentence?
No, Your Honor.
All right.
And Your Honor, there is an in-person victim impact statement. The victim.
Very good.
Hello, Judge. My name is Kanisha Pruitt.
All right. Welcome. What do you want to tell?
I want to ask for contact. This has been the longest process ever. We're expecting a child regularly. We're having a boy, and I need the support. I miss him. We need him. I need him. I need him to be around. I know he understands what he done was wrong. I'm pretty sure he won't do it again.
Few arguments carry more emotional weight than pregnancy and family stability. But Judge Simpson's response shows why courts rely on records, not promises. The phrase "pretty sure" is not enough in a courtroom. Past behavior matters, especially when the judge explicitly references prior involvement with the system. This is not a first-time mistake in the court's eyes. The judge's hesitation isn't punishment. It's caution informed by experience. He makes it clear that contact is possible, but only after measurable progress. Rehabilitation must be proven, not predicted. This moment underscores a critical reality. Courts protect future victims by requiring evidence, not hope.
And I have a lot going on. I have complications. I still have a business to run. I don't have any family or anything. He is my family. And I need my son to have a dad present.
All right. Typically, just so that you know, I am reluctant to change something from the recommendation until I could see how he does after the first review. All right.
Okay.
And part of that is because, just in putting it in a colloquial way, this isn't his first rodeo. So he's been through this process before, and what I want to make sure is that he's going to get something out of that process before I'm going to sanction any contact. Okay.
I'm not gonna, I don't have any parents or anything. Sometimes I have to work, 90 hours a week. I had my mom the first time when I did have my first child 17 years ago. I have to get a C-section. I have to go back to work a month later. I'm not even given a full 6 weeks.
Ma'am, I get and I understand all of that. However, I also have to be aware of what transpired in this case, and that, I'm here with a misdemeanor offense, but it's not as though this isn't the first time that he's committed the offense of domestic violence. So, all right. So I may be issuing a decision that won't make you quite happy. I'm not saying it won't happen, but I've got to see some progress for him before I'm going to sanction the contact.
Okay.
All right. Thank you. So it's really up to him.
Okay, thank you.
Anything anybody would like to say? You or your client want to say before I impose that?
Nothing further from me, Your Honor.
Sir, anything you want to tell me before I impose sentence?
Your Honor, I know you said this is not my first rodeo, but like I was a child, I was a young adult when I got in trouble. The first offense. I'm 45 years old now. I'm a grown man, and I'm not like making the same mistakes over and over. Like I'm headed in a more positive direction in my life.
This statement is an attempt to reframe identity. The defendant isn't denying the past. He's distancing himself from it. Age, maturity, and time are offered as evidence of change. Judges hear this argument often, but they evaluate it against consistency, not intention. Judge Simpson allows the statement, but the sentence that follows shows restraint rather than belief. Courts do not sentence based on who someone claims to be becoming. They sentence based on safeguards that account for who they've been. This is the system acknowledging growth while still enforcing limits.
I've been doing quite well for myself these last, few years. So, I just want to, say that.
Sentence of the court and place you on 24 months probation. You're to pay $555 fines and costs, $720 probation oversight fees. When can you get that paid?
Can we work out some type of payment plan? Like how would that work?
Payment plan as arranged by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. You're to continue individual therapy with status reports to probation. At this time, I will order no contact with Kenesha Pruitt. You're not to go to the residence or employment of Kenesha Pruitt. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. You are to report to probation as requested by probation, including any home visits. You are to comply with any circuit court orders, if any. I'll set a review hearing that's to be held May 5th, 2025 at 1 p.m. I will order 365 days in jail. Credit 17. The balance is suspended.
This sentencing is firm, deliberate, and unmistakably corrective. Judge Simpson is not improvising. He's escalating structure. 24 months of probation is a long leash, but it's still a leash. The financial penalties increase accountability, therapy requirements address root behavior, and the no contact order remains absolute. But the most important number here is 365 days, a full year of jail time suspended. That's not symbolic, it's leverage. This is the court saying you will either comply or you will sit. The judge also emphasizes reporting, home visits, and compliance with any circuit court orders, closing every possible loophole. This is not about one mistake, it's about preventing the next one. Do you think suspended jail time is more effective than immediate incarceration?
Thank you.
Thank you.
Thank you, Your Honor. Thank you, Mr. Driscoll.
All right, thank you.
Court calls case People versus Yusuf Cyrus.
And on behalf of Your Honor.
Assistant Public Defender Natalie Pate, and on behalf of Mr. Cyrus, who stands to my right, please state your name for the record, sir.
Yusuf Cyrus.
Thank you, Your Honor. Ms. Perroni was previously handling this case, and I'm stepping in for her today. It is my understanding that they wish to set this case for final settlement conference.
Jury final settlement conference in this case will be April 11th, 2025 at 9 a.m. Jury selection, if necessary, April 14th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the People versus Franklin Fischer.
And on behalf of the people, Your Honor.
Ready, Your Honor. May it please the court, Robert Hamburger, retained counsel on behalf of Franklin Fischer, who's standing to my right.
Your name, sir?
Franklin Fischer.
All right. What are we doing?
This time, Your Honor, we would ask for a trial date.
He wishes a jury trial on this matter.
I think so, Your Honor.
Jury final settlement conference in this case will be April 11th, 2025, 9 a.m. Jury selection in this matter, April 14th, 2025, 8:30. Both of those proceedings are in person.
What?
And just so that we're clear, I'm gonna make a change on the complaint regarding the race of the defendant that improperly listed.
Pardon?
On the complaint, they list his race as Caucasian. I think that's probably not correct. But
It might be a lot of stuff that's incorrect, but yeah, that's definitely incorrect.
and so I am correcting the complaint.
This may seem minor, but it's legally important. Court records are not casual paperwork. They follow defendants for life. An incorrect descriptor can affect identification, data reporting, and even future proceedings. Judge Simpson corrects it immediately and publicly, which protects the integrity of the record. This moment also highlights something subtle but essential. Accuracy matters at every level of the system, not just during verdicts and sentencing. Courts are obligated to correct errors when they see them, even if no one objects. It's a reminder that justice isn't just about outcomes. It's about records being right, because records last long after courtrooms empty.
To reflect.
Your Honor, may I address the court? Briefly. Your Honor, this case, the complainant told the police that she did not want to prosecute, and she continues to text the defendant, and they were out to dinner the night before he was arrested on a warrant. He didn't even know about the arrest warrant. So I would just ask if the court could remove the tether that he has on his ankle.
Your Honor, we would oppose any modification of bond. In this case, the defendant grabbed the victim around her neck and started choking her, used both hands with his thumbs on her Adam's apple, and we could not write strangulation because when she was doing the interview with officers, she was too afraid to continue. So it's only a misdemeanor because of that. So I would ask that any bond modification at this time be denied.
This exchange perfectly captures why victim cooperation does not equal case dismissal. The defense focuses on reconciliation and communication. The prosecution focuses on conduct, specifically strangulation allegations, one of the most dangerous indicators in domestic violence cases. Judges know this. Victims may recant. Fear, attachment, and pressure all play roles. But the court cannot ignore the severity of alleged behavior just because the relationship continues. Judge Simpson's denial is swift and decisive because the risk profile hasn't changed. The tether stays. Protection outweighs convenience. This is the system prioritizing safety over sentiment.
Anything else, counsel?
No, sir.
Motion for bond reduction or change is denied. Bond will continue as is.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Deanna Gray.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Gray, who is present via Zoom. Ma'am, please unmute and state your name for the court.
Deanna Gray.
Thank you, Your Honor. There was an offer extended by the people of plead as charged under 4A, which I did discuss with my client. At this time, she does wish to set the case for final settlement conference.
Jury final settlement conference, April 11th, 2025, 9 a.m. Jury selection, April 14th, 2025, 8:30. Both of those proceedings are in person. Bond will continue.
Thank you, Your Honor. Thank you, Ms. Gray. You're all set for today.
Thank you.
Court does call the case of the People versus Shelley Hayek.
Absolutely, the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Hayek, who stands to my right. Please state your name for the record, ma'am. Shelley Hayek.
There was an offer sent to the defendant to plead to an added count of operating while visibly impaired first, and 93 days to be by $300 fine, 4 points for the Secretary of State restrictions. Contrary to 257653A, I understand she is going to be accepting that offer today.
That is correct, Your Honor, pleading no contest. Excuse me.
Pleading no contest to operating while visibly impaired.
Correct, Your Honor, yes.
Is she signed any advice where it's for?
I do not believe so yet.
They were sworn.
Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Shelley Hayek.
Ma'am, it is this court's understanding you're going to be pleading guilty to the charge of operating while visibly impaired.
Correct. Your Honor.
That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right, two things about a no contest plea. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
This is a textbook plea colloquy, and Judge Simpson walks it line by line. A no contest plea is often misunderstood. It doesn't mean innocence. It means the defendant is choosing not to fight the charge while avoiding civil liability admissions. For sentencing purposes, it's identical to a guilty plea. The judge ensures understanding, voluntariness, and awareness of consequences, sealing the plea against appeal. This is procedural precision. Every "yes, Your Honor" closes a door. Once this plea is accepted, there is no trial, no jury, and very limited grounds for reversal.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And to that charge, how do you plead, ma'am?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Correct. Yes,
You signed an advice of rights form today, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor. Thank
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes,
and of your own free will.
yes.
Court has been provided and has reviewed Michigan Department of State Police report for their case number 685224. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court rule?
Be more satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty or of no contest to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be.
I'm not sure if this is supposed to be on.
It was set for a special time,
Yes, that's exactly right, Your Honor.
but I can go back to the regular.
Okay, so it'll be April 9th at 9 a.m.
Sentencing in this matter will be April 9th, 2025, 9 a.m.
Here, the court shifts from determination to monitoring. Accepting the plea isn't the end. It's the transition into accountability. The alcohol screening and victim impact panel are not formalities. They directly influence sentencing outcomes. Courts rely heavily on these assessments to decide whether rehabilitation or punishment should dominate. By setting sentencing later, Judge Simpson ensures more information enters the record before final judgment. This is how measured justice works. Decisions informed by data, not assumptions.
Bond with its conditions will continue.
Thank you, Your Honor. Thank you, Your Honor.
Court calls the case People versus Andrew McDonald.
And is it on behalf of the people, Your Honor?
Assistant Public Defender Natalie Pate with and on behalf of Mr. McDonald, who should be present via Zoom.
Mr. McDonald?
Yes, Andrew McDonald.
Thank you. What are we doing?
Thank you, Your Honor. Ms. Perny has discussed this case with Mr. McDonald, and at this time, he wishes to set it for final settlement conference.
Has he been arraigned on this? You sure there's a pretrial? I have it as a pretrial, but I don't know. He has been. Jury final settlement conference, April 11, 2025 at 9 a.m. Jury selection, April 14th, 2025 at 8:30. Both of those proceedings are in person. Bond with its conditions will continue. Thank you.
Thank you, Your Honor. Thank you, sir.
Thank you.
Court calls the case People versus Travis Oliver.
And is it on behalf of the people?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Travis Oliver.
Thank you, Your Honor. Mr. Oliver and I have been playing a bit of phone tag. I would respectfully request a very brief adjournment so that we can have a discussion about his case.
March 17th, 2025, 1 p.m.
Thank you, Your Honor.
Bond continued with its conditions. Court calls the case People versus Joseph Robinson.
And is it on behalf of the people?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Robinson, who is approaching. Please state your name for the record, sir.
Joseph Robinson.
Thank you, Your Honor. Mr. Robertson and I were first able to connect this morning. I would respectfully request a brief adjournment so that we can go over discovery together.
That objection, March 17th, 2025, 1 p.m. Bond continued.
Thank you, Your Honor.
Court calls the case People versus Kyle Smith Blue.
And is it on behalf of the people?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Smith Blue, who is present via Zoom. Sir, can you please state your name for the court?
Yep, Kyle Smith Blue.
Thank you, Your Honor. I have had the opportunity to discuss this case with my client, and at this time, he wishes to set it for final settlement conference.
Jury final settlement conference, April 11, 2025, 9 a.m. Jury selection, if necessary, April 14th, 2025, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Bond will continue with its condition.
Thank you, Mr. Smith Blue.
Can
Court calls
we,
the case
is it possible that we can discuss travel, possible travel?
Oh, yes. Send me those dates that you wanted to request, Mr. Smith
Okay.
Blue.
Awesome.
Okay,
right.
and then I can submit that to the court.
This final exchange may sound routine, but it captures the reality of courtroom justice. Case by case, decision by decision, consequence by consequence. Today we saw waivers of constitutional rights, bond arguments collapse under history, emotional pleas weighed against public safety, and sentences crafted to enforce accountability without abandoning rehabilitation. Judge Simpson's rulings were consistent. Records matter, patterns matter, and promises alone are never enough. The broader implication is clear. Court isn't about persuasion, it's about proof. And every choice made before, during, and after these hearings carries lasting consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.